John Bartlett, Attorney John Bartlett, will be speaking today and helping us guide through end-of-life documentation and all the very important information that often comes at a very critical time within our lives. We're often asked to make very difficult decisions when we're not prepared emotionally or sometimes physically really to do so. And to be as prepared as possible really helps that process for families. So we're very thankful for John. He's sharing his talents with us. John and his family come to the later service, so if you're an early service person, you might not have seen John before. And somehow related with Linda. I don't quite have the whole thing down. Linda's related to lots of people here. So did you want to say anything at all, or can John jump right up and start?
Yes, I'm going to be doing the second part, the making the choices.
Okay, great. And Linda's going to be co-doing as well. So, John, we appreciate you being here.
I didn't realize I was going to be the first one taped there. I may have said no to that. Hello, everybody. Happy Mother's Day, first off. It's nice to see everybody come in. As Pastor said, I go to the 10:15. Usually I have my 2 children with me. I luckily got them not here today, so they won't be running around and screaming or just yelling randomly. As Pastor said, I've been an attorney for 3 years. I've been in Erie since 2012. My wife is good friends with Linda's daughter-in-law and son, and we kind of just are adopted into the extended family. So that's a little bit of a background. I practice at Vendetti & Vendetti, that's on Liberty Street in Peach. They've been in law practice for probably 40 years or so, so that's a little background on me. Any other questions you can ask me afterwards, or if you're bored in the middle, no problem. I'm going to do the Wills 101, okay? I'm going to be talking about drafting a will, what the probate process is, inheritance tax as well. One thing I notice, when people come in to see me, the first thing they ask is, how do I avoid probate? How do I avoid paying anything to Pennsylvania? And I tell them, first off, probate and inheritance tax are 2 different things, okay? The probate process is really the process that the will is taken of the deceased individual. It's taken down to the Register of Wills on 6th Street, and estate is opened up, okay? At that point, an executor who is named in the will, which we'll get to later, is sworn in to basically distribute according to the provisions of your will, okay? Probate has a small fee. Pennsylvania has a flat fee based on the size of your estate. If your estate's $50,000 or less, it's $50 plus cost of computer. Or, they put it in the computer, they make it available throughout the county. So it's relatively small. You're not paying a 2% of your full estate, you're not paying a 3% of your whole estate. It's a really small fee to probate, okay? And again, based on the estate size. That differs from the inheritance tax. And I don't know what just happened. Okay. And I'm going to talk about the inheritance tax after I just go through the probate process, okay? Probate process starts by bringing the copy of that last will and testament down to the Register of Wills. You need to have a signed original copy of that will. All right, that means it has to have the person's actual signature. You can't just photocopy and bring it down there. They want to see that because they want to see that the person actually signed. You're not just taking up somebody's signature, photocopying it onto a new document. Also needs a certified death certificate. It's pretty self-explanatory, I believe. You have to file that. That's just a $10 fee on top of the probate fees. The executor of the will should be present when you go down to the Register of Wills. At the point that you probate that will, you give that will to the Register of Wills, they're going to see who the executor is, ensure that that is the correct person standing in front of them. They're going to swear you in to follow the provisions of the will. So you're basically saying, I'm going to follow the wishes. Okay? And then again, pay the probate tax, which is very reasonable in regards to other states. Other states do like to gouge you. Once the executor is put in place, you organize the assets. When we get to the second part, Linda has a wonderful journal of assets that Sean Wiley's office puts out, and we'll be showing you then. It just kind of lists all your information. So that way, when your executor is looking for your assets, because people have accounts everywhere, you know, retirement accounts, stocks, bank accounts. That's fantastic because your executor, and usually your attorney for the estate, is looking everywhere for these assets, getting in touch with all the institutions. Keeping all that information together sometimes is a little nerve-wracking for some people, but in the long run, you're really alleviating a lot of searching. At that point, you're going to value any assets that are in the estate. When you pay that probate fee at the beginning, you're really just giving an estimate of what you think the estate's going to be. And the third step is actually finding out how much is in the estate. Then you have to advertise in the Legal Journal, the Erie County Legal Journal, and the Erie Times News. The reason for those advertisements is basically they want to make sure that any creditors that you have can get their piece. They send it out once, try to think, it's 3 weeks, 3 issues of the Legal Journal it goes in, and I want to say 3 days of the Erie Times News it goes in. That basically says, you know, Home Depot, John Bartlett has passed away. If he owes you any money, get in touch with this attorney or this executor, okay? Then, once you get all the debts for your estate, all your assets, you're going to pay your Pennsylvania inheritance tax, which nobody likes to do, but unfortunately, it's very, very tough to get around. Pennsylvania inheritance tax takes any asset into account except for very few exceptions, like life insurance, certain other annuities will go around it, but even if you avoid probate by naming a beneficiary on something, Pennsylvania still considers that an asset, and you're still going to have to pay inheritance tax, okay? It's a tough thing to say because a lot of people, as I said, get probate confused with inheritance tax. So if they think they name somebody on the account, they believe that that inheritance tax isn't going to grab some of that money, and it's just not true. Pennsylvania is very good at making sure, you know, everything is accounted for. Pay debts on the estate, you do that after the inheritance tax. Inheritance tax comes out first, pay the debts, and then you distribute to the heirs. Okay, you probably in there will have to retitle. Do you have a question?
I was just curious, talking about the state share, if you would.
Yeah.
What kind of a percentage do you know?
We're going to go right to that, and I think it's the next slide, unless I messed up the order. So I can't promise. I don't do a lot of PowerPoints. I just got a new computer, so this could go wrong at any point. So you're going to distribute based on the will. That means retitling property. Some people liquidate homes as far as the estate will sell them. It goes into the estate account, and then, you know, but basically not going to get into the minutia. You distribute to the heirs, okay? And here you go, Pennsylvania inheritance tax. I should have put it in black because I can barely read it from here. No tax between spouses or to minor children. So I have a 3-year-old and a 9-month-old. If I die today, no matter where my money goes, which is probably like $80, it's going to go free and clear of any inheritance tax, whether it goes to my wife Natalie or goes to Jack and Tessa, okay? Because they're in that first category. Second category is direct descendants or ascendants. If it goes to your children when they're out of being minors, your parents, if you don't have children, or your grandparents, if there's nobody in the parent or children's class, you're paying a 4.5% tax on your money. And that's on anything except, like I said, life insurance and some other annuities that are just designed to be out of that class of inheritance taxable things. If you don't have children, no parents, or you designate going to siblings, it's a 12% tax, okay? Pennsylvania is more forgiving when you have a straight line. Parents, child, grandchildren. As soon as you deviate away from that, that's when they start to hit you pretty hard. Anybody else? If I give, $10,000 to Linda, she's gonna get taxed, or it's gonna be taxed at 15%.
You didn't give to the church?
No. It's the very last line. That's, you guys are great though. You just go to the next thing. I'm fantastic. I love
I
it.
do have a question.
Yes.
Go finish first. And then-
Oh, well, you bring up a good point. If anything's exempt, tax exempt, charitably exempt, or government entities, no tax.
Okay, like in this business, I don't know, maybe you're gonna touch on it too, like
Mhm.
have your house and say, like they say for us old folks, you go and sell it off to your kids for like so much money or
Mhm.
whatever, so that you can still live there.
Yeah, I know what you're
Do
saying.
you pay, you don't have to pay big time.
Well, if it's a transfer during life, you probably won't have to. I mean,
So it's
it's,
smart to unload.
How long do you
Yeah.
have to do that before you're,
as long as you have the capacity to do that. A lot of the time frames that you hear about are involved with qualifying for Medicaid or Medicare.
okay, but
That's-
that might be the situation that you would
Right.
be into.
When you get into Medicaid planning, you have to do any sort of transfers 5 years. They look
It
back
has to be
5 years.
Okay, back 5 years.
So,
That's what I want to
yeah,
know.
that is very unforgiving. They have very limited transfers that are exempt. They do allow an exemption. I don't want to get into a whole Medicaid planning thing right now, but Medicaid does allow an exemption for a home. The one caveat for a home, up to, I believe, 500,000 value. The one caveat is you always have to intend to go back. So if I get a terminal disease, I have to get round-the-clock care at a nursing facility. They're gonna say, oh, that's great, but you need to sell your home because those are now available assets that you're not gonna ever go back. So that's when people say, I gotta go to the nursing home and they're gonna take my home. That's what they mean, because once you don't have the opportunity to go back or the possibility of going back to live there, that's when Medicaid says, well, that's now an available asset.
But
Okay?
what if there's a spouse involved too?
Well,
They
if
don't-
there's a spouse still living there,
Right.
then they
But
won't do
then
that.
once that spouse dies, does then that house estate go to pay for the bills from the first person that was it? Now, that's my understanding is how it works.
Okay, so,
Say my husband was in a nursing home and he
Yeah.
had to go on Medicare. We still had a house,
mhm.
okay? And he passed away, but I didn't have the money to pay for his care.
Mhm.
Then they attach to my house, once that I pass away, the selling of the house then goes to that nursing home
Well, I mean,
to pay for his bills.
it depends how you held the home, because if you hold the home as tenants by the entireties, which is the designation for married couples who
Okay.
hold the home, any lien that comes because of one person's actions, so shouldn't be able to attach to that home. Because if I hold my
That's not
home,
my understanding.
I mean, I can't, I don't know, because
I guess
every situation in that, sometimes when Medicaid, somebody passes away, they won't even pursue the amount they have. So each person's kind of different. It all depends.
Right, on what your
Right,
pension
so
and whatever.
Without any
money
sort of
they can-
specific facts, I can't give you an answer. Every case is different.
Where do you get that, who would you contact to get that information?
Well, you may want to contact the Medicaid office itself,
Okay.
because I usually deal with when the people are getting to that point when, somebody's passed away, there's these liens, and every time it's different.
Okay.
I've sent out numerous things to the Department of Public Welfare in Pennsylvania to see, hey, this person was on medical assistance, what do they owe? And 50% of the time I get something back, well, they received benefits, but we're not gonna pursue it.
Oh, okay.
So
All
every's different. I mean,
Right.
if it's an outstanding amount, then I wouldn't be surprised if they try to lien the home.
right. Okay,
Okay.
all right.
Okay.
All right, I'm sorry.
No, don't be sorry, don't be sorry. So that was, anybody have questions on the probate process?
Going back to the inheritance tax. The
Yes.
inheritance tax is paid by whom?
Inheritance tax is gonna be the first thing paid out of the estate.
Paid out of the estate before it goes, is distributed
Correct.
out to the banks.
Correct. And a lot of people do that because if I have 50,000 and I've given 10 to Linda, I want her to get that whole 10.
Right.
So that inheritance tax is gonna come out first. She's not gonna be responsible for any of that, and it's not gonna put any sort of lesser amount to her.
And it doesn't show up on anybody's personal tax returns, right?
No. No, you actually file an inheritance tax return with the Department of Public Welfare. The attorney or the executor will put that together. It has to be approved. They send it back to you, I think, 4 months or so after you send it in. And at that point, you either can contest it if they want more money or less money, or they just say, we accept this. Okay? Any other questions? I saw one more hand. No? Okay. What is a legal will according to Pennsylvania law? You can, if you have a
I
question.
was gonna ask you a question, but I forgot.
Oh, that's fine. Well, if you remember, just stop me. Yeah.
ready for the nursing home.
If you remember, just blurt it out. Okay. Age and mental state requirements. You have to be over 18. You have to be a sound mind. If you're not of sound mind, you're being coerced. Sound mind. Yeah, sound minds, you know, it's, yeah, it's relative to writing and signature requirement. Every will has to be in writing. Any oral wills, any oral agreements, Pennsylvania does, it takes a lot to get Pennsylvania to recognize them, and they're not gonna do it when it's a will.
Does it have to be done by a lawyer?
No.
Can you take it, like have a will and take it then to like a justice of the peace or something, or
Notary
a
public.
notary and have them put their stamp on it and hold that?
Yeah.
That would be, that's legal and
That
valid.
is, that's legal.
Oh, okay.
You don't have to have it done by a lawyer. They just, you know, a lawyer just drafts it and they have their templates and all that. So I don't recommend one way or the other. I mean, there's so many legal Zooms and all those out there that.
I mean, there's
you
a
know.
lot to pick and choose from.
Right.
Not a question, but on that question, sometimes a lawyer will bring up things you hadn't thought of.
Right.
Oh, yeah, but I'm just, you know.
What's the average fee usually for that, for a will?
It depends on, usually it depends on what the will includes. If it's a simple will, personally, I charge about $150.
Okay.
And that's just to come in, sit down, discuss what you want, make sure you know who you want to give to, why you want to give to, who you want the executor to be. You get into some of these situations where people want to set up trusts, they want to have somebody, you know, then depending on the amounts, that it can go up. I'm more reasonable than some other places. I'm more of a solo practitioner, so if you go to me, it's just me. If you go to like a Knox, they're going to be a little bit more because they're a big firm. And
Right.
that's not a knock on them, they're a very good firm. And they have some good lawyers there. Okay, so it has to be in writing and it has to be signed by the testator, who's the maker of the will. If the testator is unable to sign themselves, they may direct a third party to sign for them. When that third party does, two witnesses have to be there to notice or to hear that person declare that that is going to be their will. The same thing happens if you write your own will and you sign it. You want to have two people witness your signature.
Can they be relatives, or do they have to be?
I recommend not to be anybody in the will.
Oh, okay.
Okay,
All right.
but they can be anybody. We do, when you come to my office, I always, if I'm not listed as the attorney for the estate, I always am one of the witnesses and I always get another attorney there. That way, you know, you can at least find me or just call the office and we'll find out who the signature is.
Okay.
But that leads to the next point. The signature of the testator must be witnessed by two people. Most wills have it where the testator and the two witnesses all sign the will at the same time, and it's notarized. That's what's called self-proving. So instead of having, when you take your will down there, you just have your signature on there, you have to bring your two witnesses with you down to the Register of Wills office so they can say, yes, John signed this and he wants it to be his will. You have two people sign it as witnesses and it's notarized at the same time. It's considered self-proving. You take it down to the Register of Wills as executor. They look at that and they just, admit it into probate, and then we'll give you the ills. I do it this way because it just eliminates a lot of hassle. Finding witnesses, finding times that the three of you are available to go down there, just makes it easier for everybody. And I don't like to hassle other people, so I try to make sure everybody does it this way. I'm going to quickly go through the standard clauses of the last will and testament. I don't want to step on Linda's toes, so she has plenty of time to talk. Introduction clause, that's not my actual will, but that is what it would say. That I, identifying myself, identifying where I can be found, makes and sound mind and judgment and legal age. One thing, if you make a new will, all your previous wills and codicils become revoked, okay? First clause is the funeral expenses and inheritance tax. That's saying the first thing out of my will, first thing out of my estate, I want funeral expenses, inheritance tax. That way nobody else is going to be responsible for those, okay? Some people do the irrevocable funeral trusts that basically pays for your funeral while you're still alive. So you don't need that language, but just in case, there's some sort of fees. Those are the first items to be paid out of the estate, except for costs to open the estate. Those costs to open the estate are usually paid by the executor, but they will get them back out of the estate funds themselves. The bequeath and devises clauses. This is where you list your heirs and what part of the estate you want them to have. It can be general or specific. Specific. And that's just an example. I give to my son, Jack Bartlett, my collection of baseball cards. One thing with specific clauses in this,
I can't do that.
you want to be specific. If it's something that is, like if you're giving a watch or you're giving something very specific, and you want to make sure that you can identify where that is. I mean, obviously some things are movable, but you can give some sort of description of what it is. General is, I give and devise, bequeath to my beloved wife, Natalie, my entire estate. And then if it's two people or more, devise, bequeath, Jack and Tessa, my entire estate in equal shares. So that's pretty general. That's what most people have. But again, you can get creative. You can give $10,000 to Luther. You can give $10,000 to Linda, and then you can give the residual. I mean, Linda's going to be making out at the end of this. And then you just give the residue of your estate to your heirs or whoever you would like. Executor powers. I just rose. Basically, you're just saying you're. Go ahead.
One thing, you're speaking of young children.
Right.
Okay, when you come down to adult children,
Mm-hmm.
say 2 children, you're going to split it in half, and then comes a question, if one of your children die, does it go to his spouse and family, or how does that direct?
There's 2 terms you learn in law school. It's per capita or per stirpes. And you've never heard the per stirpes before, but that basically says I'm giving those shares equally to my children, regardless of if they're alive. So that you're say Jack is still alive and Tessa has passed away, which Tessa had 3 children. Jack's going to get 50%, but because we're going by the per stirpes distribution, Tessa's 3 children are going to split her 50% as well. Now, if you do a per capita, that is where it takes a class and spreads evenly. And each class is talking, children, grandchildren. So in that case, Jack would get 100% because his sister hadn't survived. But most people write it per stirpes. It's right in the will. I always, after this language right here in equal shares, it will go blah, 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 and at the very end, it will say per stirpes, which means if somebody passes away, that share still travels.
It doesn't go to, if the surviving family or had a husband, it wouldn't go to him,
No.
it would go to the children?
Correct.
Okay, all right.
Correct.
Gotcha.
In that case, the husband may end up being the trustee for that,
Right, okay, so the children.
you know,
were
for the children until they become minor, but,
Gotcha.
I mean, it's how comfortable or how in-depth you want to get in your will. I just did one the other day where they very adamantly wanted their son to be the trustee if there's something happened to the daughter for her children.
Oh, okay.
So it's, you know, when it's that important to somebody, you can go right in and make that language available. Executive power is basically, you're just empowering your executor to take your estate, sell it, transfer it. It's pretty standard. Okay, picking the executor, very tough to do. A lot of people don't want to hurt feelings. A lot of people just want to be fair. I say fair is kind of not, this isn't something you want to be fair with. If you have an accountant for a son and you have a wayward daughter who's never around, go with the accountant. You know, because this is your estate. This stuff isn't, it's easy, but you have to be organized and you have to be thorough. So if you're not going to be there, or if your daughter's not around or tough to get a hold of, the estate's going to drag on. It's going to take a while for everybody to distribute. If you have somebody who's very meticulous, who's, you know, on top of things, they're going to be the pick. Okay. Every will I've done deals with this issue of just being fair, you have to, and I use my brothers for an example all the time, and you know, Linda has met my brothers at my wedding, and one brother I'm very close to and I love to death, and he's a district magistrate out in Massachusetts, same thing. He could do it, but my other brother is, you know what, I love him, but I don't want him anywhere near my money. Great guy, but you know. So I mean, it's just one of those, you have to pick who you trust.
Should they live in the same state or same area that you?
It makes it easier.
Okay.
But a lot of people you always have an attorney for your state, or almost always, so a lot of that will go through the attorney. So you can be out of state and still have your estate get done.
Okay.
Question?
No, I just have to notice on the second last line of both executors.
Oh, yes. Yep. You always want to, no, that's fine. Co-executors can be a bad idea because, exactly, you have to have two minds agree, and if you get three, forget about it. You're going to have an estate that lasts for 6 years. Always want to name a substitute executor. People pass away. Some people just don't want to do it. You know, they say, hey, no, I don't have the time. Things are, always name somebody because you want to keep control of your estate and make sure that it's going to be distributed correctly. Linda, I'm trying to go as fast as possible. Oh, you let the end decide, so. That might be the end. Yes, it is. So after you go through those clauses on the will, you're going to have your signature page, which, like I said, the two witnesses, signature. We'll go there. Any questions real quickly?
I have one. This Linda, a lovely lady who's getting all this money, who's not related to any of us, is she going to have to pay federal and state income tax on that $10,000?
No.
No.
No. Inheritance taxes. And he's an accountant, so he's the one to ask there. But inheritance aren't taxed. They're paid through the inheritance tax, correct?
Correct. You're paid through the estate before it comes out and you don't touch it.
Right.
Who has the original will? I mean,
You have a copy.
I do? I think I have a copy, but who's got the original?
You come to my office.
Yeah, she's not a silent time.
You blame me, you
I
can come
do.
on the ride with me.
Okay.
You come to, when anybody comes to my office, I always make them sign two. One you take with you, okay? Well, I tell you, either give it to your executor or put it in a safe place that they can find it and they know about it. The other one stays with me. Because when you lose it,
Yeah.
or your executor can't find it, they can come to me and I'll have it. If you do not have an original copy, you have to go through a whole other motion through the court system. That's money, that's time. So you want to have a copy. Because if you don't, you have to petition to have that photocopy probated. Okay?
Linda has a
I have a question.
Oh, no.
I just read something about having it on like a zip drive.
You can, but even if you print it out, and even if you print it out in color where it's still signed in blue, the people down at the Register of Wills will actually physically touch it and examine it to make sure that it is an actual pen in print. So you can't fool them. We've tried. Not me. But no, I'm trying to think, one of the other guys in our office had that where they had sent the photocopy and they look, they make sure. All right. So I'm gonna give you Linda right now, and I'm sure I'll.